Greetings, and welcome to the DC Bar Pro Bono Center's Nonprofit and Small Business Programs podcast series. On a monthly basis, we talk to experts on legal topics of note to nonprofit organizations and small businesses. I'm Darryl Maxwell, Assistant Director for the DC Bar Pro Bono Center. We have been lucky enough to have the co-sponsorship of our friends at the Center for Nonprofit Advancement, an organization that expands professional development opportunities, access, and capacity for nonprofit organizations throughout the Washington, D.C. region. Today, we're going to focus our attention on for-profit businesses. We'll be discussing non-disclosure agreements, and I am pleased to welcome my friend and colleague, Heather Batzel, to help us with this. After a decade of corporate legal practice in the heart of Washington, D.C., Heather Batzel opened Batzel Law PLLC in 2013, representing the World Bank in international transactions, positioning new companies for success, serving as general counsel at a startup company with contracts executed on 6 continents. That's a pretty big deal. And handling corporate and securities deals from Main Street to Wall Street, have seasoned this corporate attorney and given her a broad, savvy perspective, keen insights, and down-to-earth understanding of the needs that arise in day-to-day business operations. Heather is a strategic corporate counsel, an expert contract drafter, skilled negotiator, and in all cases, a zealous advocate of her clients. She has worked with companies at all developmental stages and of all sizes, but now focuses on providing new and growing companies and their founders and executives with legal counsel throughout the full life cycle of their companies. Heather holds a Bachelor of Science from Carnegie Mellon University and a Juris Doctor from American University. Heather is licensed in the District of Columbia, Maryland, Pennsylvania, and Virginia. I feel like you're just sort of trying to rub it in by having so many states, but Heather is also a frequent volunteer at the DC Bar Pro Bono Center's Small Business Brief Advice Legal Clinics. Welcome, Heather.
Thank you so much, Darryl. I'm happy to be here.
Fantastic. So today we're going to be talking about non-disclosure agreements, and for quite a while now, particularly in the era of Stormy Daniels, now with the emergence of the Me Too movement and with recent scandals, including those involving Facebook and Uber, non-disclosure agreements are extremely important, more now probably than ever. And it's really important for entrepreneurs and business owners to protect your business interests, but also to understand what you may be agreeing to when you sign a non-disclosure agreement on behalf of your business. Heather, in your background and expertise, generally, why would one of your clients ask you to draft a non-disclosure agreement? Secondly, who does the agreement protect?
Yeah, great questions. Well, generally speaking, non-disclosure agreements, also known as confidentiality agreements, they come up frequently, and they often come up very early. They come on the radar of people and entrepreneurs in particular that have developed ideas for a business, or they're starting to implement those ideas and start to run a business because they recognize that they have something that they want to keep as a secret. They don't want their concept, their game plan, or their secret sauce out in the world when they're trying to actually build a business on that secret information. And so a lot of times people come to me and perhaps they've formed their own company, or perhaps they're coming to me to ask me to help with that as well. And they say, but what I'm really worried about is making sure that I protect this thing that I've developed that I think is really, really awesome. And I want to go talk to so-and-so, or I want to hire my first employee or contractor and make sure that they can't use my information for anything else. So that's the common context that I see that brings someone that makes them reach out to me to ask about a non-disclosure agreement. And then the flip side is a lot of times people or companies have received a non-disclosure agreement, or an NDA for shorthand, that they are being asked to sign, and they want to understand what it is that they're really agreeing to. And then looking at your second question, Darryl, kind of who do they protect? and what do they protect is the very crux of the question. So that depends on what the agreement says. Contrary to a lot of public opinion, these legal documents called NDAs or non-disclosure agreements or confidentiality agreements, like I mentioned, can actually be fairly complex, not extremely complex, but fairly complex. They are not one size fits all, and they may or may not accomplish the actual intended or helpful purpose if they're not looked at with some, due consideration and care. So even thinking about, what does this agreement cover? What confidential information or what information that I want to share? Let me rephrase that. How will the information that I want to share be covered or not covered by this agreement? Is this agreement going to bind both parties or more than two parties, or is it just binding one party in the transaction? And are there any other limitations as to how and when this agreement is going to cover the stuff that I'd like it to cover? So, I mean, that's a very big picture look at what these documents do, but of course the devil's in the details, and I can talk about all of those things.
Sure, sure. So one of the details that I've had some clients who've had questions about, usually they've been presented a confidentiality or NDA, a confidentiality agreement or a non-disclosure agreement, and after sort of reviewing it, you realize, oh, this is very much so, a one-way agreement. And I've seen it. I've also seen it in sort of the mutual NDA or sort of two-way NDA. And I wanted, with your expertise, I wanted to sort of get a sense for if, particularly for like a smaller, smaller entrepreneur, what are the best ways for them to either help themselves or sort of prepare themselves if they have a one-way agreement, or if they're lucky enough to get a two-way, sort of what that might mean for them?
Well, if someone is trying to, help themselves as much as they can, I think one thing to think about is if you're being presented with a one-way NDA that someone else is asking you to sign, you should think about whether or not you too will be sharing any information in the discussions that should be kept private and confidential. And you should also think in terms of when you look at each provision of the agreement, is that something that you think is reasonable or overly burdensome, both from the perspective of keeping something confidential, as well as, if you're the one that is bound to keep it confidential, as well as, is this protective enough if you too are going to provide some information? And I think sometimes even just going through that process of wearing both hats, both as the discloser and the person receiving the information, the recipient, you can really, with some thought, get a good sense as to how this NDA is going to operate. So that's one thing, just really looking at it in detail. You need to look at how not only the definition of confidential information, so what all does this say is going to be included, but also most NDAs are set up to talk in terms of information that is being shared for a particular purpose, or sometimes a broad purpose. But it's not always, it doesn't always utilize that language, quote, purpose, but it often does. It defines what the parameters are of a discussion for which information is being shared among parties. And you want to think about carefully crafting that purpose to make sure that that whatever you disclose is protected. So for example, if the purpose says the parties are disclosing information to each other for purposes of party A buying party B, but then you share information that doesn't have to do anything with that transaction, but actually has to do with selling some consulting services, technically you've just gone outside of the purpose of that confidentiality agreement, and that information might not actually be afforded confidential treatment under the non-disclosure agreement. And then the flip side is that a lot of NDAs define the purpose really broadly. Like the purpose is a business, a discussion about potential business between the two parties. And sometimes a really broad purpose makes sense. But then you got to think about it from the other perspective, which is that everything's confidential. Or everything falls within that purpose, all that information you've shared. But sometimes purpose is used later on in the agreement to also allow the confidential information to be used for anything that's related to the purpose. And so there you can see that if you have a really broad purpose, you might not be thinking that you want to grant as extensive of a right for someone to start using, assessing, and sharing within a certain subset of people that information for anything that could conceivably be a collaboration between you. You might want to limit it more by having a more limited purpose. So this is kind of the devil in the details point I made earlier. When you start to unpack each provision, each defined term, et cetera, you see that you need to give some thought to tailoring it to your particular needs.
No, that's a really good point. I've definitely seen some, typically, we'll have entrepreneurs that come to us or looking for assistance, and they're using, either they're trying to provide to somebody they're looking to partner with, a extremely broad NDA or confidentiality agreement. And, while it might be helpful because it's fantastic to keep this stuff confidential, and it sort of leans toward their sort of means, having it work through, having it be extremely broad like that I feel like can present real legitimate problems, problems that you weren't even aware of when you sort of decided to go down this road.
Yep, I agree. The other thing I think that's really important to think about related to this first subsection we were talking about what is confidential information. I mean, there's this one version of defining confidential information I see from time to time. It's a form of NDA that I'm not a big fan of, and that is because it has this language that says confidential information only includes information that is clearly marked as confidential on each piece of paper. And insofar as a conversation takes place, you have to, within some amount of time, sometimes it's 24 hours, reduce to writing what was discussed that is confidential, noting clearly that it is confidential, and provide that to the other party. And I see this every once in a while, and I'm usually shocked because I have not yet met a business person that I believe actually has done that when required in order to get the confidential treatment. I just think it's just not realistic. And perhaps in some really high level, government secret level discussions, one has to be that meticulous, but I think it's not practical or practicable for most people. And I don't, so I don't like it for that reason. I just saw it actually in another NDA recently. It just comes up from time to time. I think a lot more reasonable language is to say, language that is not public, that is being relayed to you as part of the discussions that are for the purpose, and that are maybe even add the language reasonably expected to be of a proprietary or confidential nature. I mean, I think that is much better language because it's more likely to get that confidential treatment. And then the other thing that's something to keep an eye out is that sometimes you'll have exceptions to the restriction from disclosing confidential information. Like if in their fairly standard, like it's not a breach of your duty of non-disclosure to provide information in when a court orders you to, or the government orders you to. Makes sense. Typically people are not going to agree to not comply with legal authorities if they have to. And there's some other exceptions, but that, for example, shouldn't be an exception to something being confidential information. It's an exception to one not being allowed to talk about the confidential information. So you have to make sure that it all hangs together okay.
No, that's an excellent point. Now, in addition to sort of the sort of broad purpose, one of the things I was hoping for you to dig in a little bit on was the the timing and sort of the effective date
Oh
of,
yeah.
and as well as just, you know, I always want to make sure to give folks a sense of, you can't, confidentiality can't last forever, or, and in some cases forever can, like, 2 years in a really sort of, in a transaction that could mean, lots of money for a business owner. 2 years or even 2 months can be a significant amount of time. Even with the understanding that, it can be different depending upon, the type of transaction. Just, I'd love for our listeners to get a sense for what timing at least should look like, with an NDA like this.
Yeah, well, that's a great question. I mean, I do see a little bit of a gamut. I mean, you will depending on what it is, you will sometimes see an unlimited, one that doesn't terminate. Like, for example, information that people learn while an employee at a company that, you're not allowed to talk about it. You're not allowed to do anything with that information. Maybe that one would be ongoing, but sometimes you'll see like maybe a 5-year limit. But I agree that 2 to 3 year, 1, 2, or 3 year is what I see, I think, most often. Again, one really needs to think about how and when will the competitive disadvantage like be there or not. And if you really are going to, if this is a secret, like it's a trade secret, like the Coca-Cola recipe, then maybe the more realistic approach is to not share that recipe, right? Because as they say,
Right.
something's not a secret as soon as you tell someone else. And so that's not really the legal standard, but from a practical standpoint, you certainly run the risk of irreparable harm, something that can't really be undone. So I think, thinking in terms of, is this information still going to be valuable? Like you might say, well, no one ever needs to disclose the financial information about my company's metrics. There's just no reason to use and disclose that information other than for purposes of this agreement. And so there you might have, not necessarily term limited, but I think the other side to look at is when does the confidentiality start? Now, typically it's going to start when the non-disclosure agreement is signed. But sometimes, and I typically ask this question when I'm working with someone on a non-disclosure agreement, particularly if I'm representing the person or party that is disclosing information, I will say, when was the first time you gave them information that you want to have be included here? Because if you already told them all of your key secrets last week and we're just getting around to drafting and signing this non-disclosure agreement today, then it doesn't do anything for that prior information unless we make sure that it specifically does. And what I would recommend there is to just have an effective date that is, a week or a month back, whatever the timeline is. And, unlike other areas of law where you can't backdate, I mean, you can't backdate in like securities and tax related areas of law because there's a consequence, and it usually has to do with avoiding paying or complying with requirements that the government's putting on you. So you can't do that. But when it comes to a commercial agreement where you're saying, just to be clear, I want you to keep all of that information secret and confidential, and there's something called quid pro quo, as Darryl, you and I know, and in consideration, where each party has to get something. But generally speaking, I think that the discussion itself and the promise of the possibility of collaborating to do a mutually beneficial deal will probably get you that consideration if you want to date the agreement back a week or 2 or a month or whatever the applicable time frame is within reason. I don't know that you could backdate it 5 years and have that be enforceable, but so you want to make sure that the start date reflected on the NDA really captures all the days that you've been providing confidential information.
Okay, and I have wanted to get to a nugget on sort of, is there a particular standard for what or would there be a particularly defined term for what confidentiality means? I imagine there has to be confusion when this comes up between clients, and so I'm just curious if there's a particular set of rules that you follow, or if there's some place you can point our listeners to sort of have the best idea for what confidentiality actually means.
Yeah. Well, I love that question because it's actually something I hone in on when I'm drafting or reviewing a non-disclosure agreement. And that is, what are all the obligations that are included here when we talk about keeping something confidential? So one is, as the agreement often is called, non-disclosure agreement, one is the requirement to not disclose. You're not supposed to disclose the information to anybody else except people that are particularly allowed within the agreement. So usually an NDA is going to say, okay, if you're sharing confidential information with a company, clearly like the company cannot actually read the information. It's people that work for the company that are agents of that company. So, it'll usually be defined who's very specifically at the company can look at the non-disclosure or the confidential information, or more specifically, or let me rephrase that. It will typically be identified who specifically or who generally is allowed to see the confidential information. So a lot of times it'll say representatives who have a reasonably necessary need to know that information. And it will sometimes also say only those people that need to know the information who have also signed a non-disclosure agreement or have confidentiality undertakings in their employment agreements that are basically the same as what we have in this agreement. So that's prong one, non-disclosure. Prong two, non-use for any reason besides the purpose. So, it's not just that you don't want someone to use, sell, or publish or share with someone else your just confidential information. You also don't want them to use it for their own purposes. You only want them to use it if it's together with you for something that you've decided that you're going to move forward with together. So that not using it for any reason other than the purpose that should be, in my view, typically narrowly defined, like we talked about earlier, that's another prong. Another prong of what confidentiality entails is that there might be a standard imposed. Like, you have to keep, when we say you have to keep this information confidential, we mean you have to maintain it in a secure fashion that is either commercially reasonable or maintain our information at least in as secure of a manner as you maintain your own information. So setting a standard of some kind. There could be other versions of that as well. And then another thing that is sometimes included in the specific undertakings in a non-disclosure agreement is how and what you need to do when the agreement is terminated. Like, do you have to affirmatively give back the confidential information, and what does that look like? What kind of erasing off of your machines is required as part of this agreement? And then there's a few other things, generally called restrictive covenants, that sometimes are included in NDA and sometimes aren't. And those include things such as non-solicitation and non-circumvention, which has to do with not using the information or the contact that you may have learned about to go around the person that disclosed the information and strike up a business deal directly with their subcontractor or their employee or their customer.
Sure. Okay, while you were talking, it made me think of a particular point that I've talked with clients about before. I have some ideas about what I think the answer is, but I wanted to run this by you. So in the event that two entrepreneurs have entered into, or two businesses have entered into an NDA, and through some sort of set of events, an employee, typically someone who wouldn't have signed an NDA or who is of I will just say is probably a sort of more a frontline employee, less of an executive level employee, whether out of malice, spite, negligence, or indifference, shared information that was a part of the NDA, that's included in the NDA, whether by accident or again or on purpose. I'm guessing, particularly the way that as your bio mentioned, you're such a skilled contract drafter. I'm going to imagine that the penalties for violating the NDA are going to typically be fairly hefty.
Yes, and it it depends on, as always, depends on in large part it depends on what the agreement says. That's not to say that if you didn't have any language with respect to what damages would be or wouldn't be, that the courts and case law and common law wouldn't have some solutions. But sometimes the non-disclosure agreement is going to have language that talks about how the situations will be handled. Now, sometimes, although I wouldn't say this is the most customary, but sometimes you'll have liquidated damages provisions. Liquidated damages provisions are something that you need to assess with respect to the given state law, whether or not that would be something that would actually be enforceable. But it has this intention of trying to not have to go to battle to prove what the damages are from a disclosure, an improper disclosure. It can be hard to prove what all damages happened from a bad act or a disclosure, inadvertent or malicious disclosure of information. And so liquidated damages are something that one could consider a per breach cost or fee penalty that the parties agree in advance will be the what's the word, the stipulated damages for a given breach. So that's one way. Another, there's also language that's often included that just talks about not having to get a bond in order to take someone to court, or it being agreed ahead of time that if we think that a party is disclosing things they're not supposed to, that would cause irreparable damage. And some of these terms have the effect of streamlining the process, making it easier to get into court and to get, for example, to get injunctive relief, which will make the other party stop doing that thing they're not supposed to be doing, while we then sort out the damages and or any other questions after the fact. So there's just some mechanisms that you put in there in order to try to streamline that process and make it easier for the party whose information is being disclosed improperly to get some relief from the court. So that's one thing. The other thing that comes to mind from your question, Darryl, is that it's a good lesson for entrepreneurs with their own companies who might have employees, because in the end, your company is likely going to be the one that has to foot the bill. So that really reminds one that they really want to have agreements in place with their staff, whether they're employees or contractors, co-founder partners that are not employees or contractors, they're just working as maybe members in an LLC, and really make sure that the terms are clear with those parties as to what their requirements are, and just a general code of conduct, making sure everybody understands how information is to be treated.
Thank you. That was exactly the type of fulsome answer I think
Good.
Our listeners are going to be really serve our listeners well. I just had one last question I wanted to make sure to get to, just in the means of sort of closing this discussion. Just any sort of thoughts, any interesting sort of non-disclosure agreement related sort of matters you've come across over the span of your career working with entrepreneurs that you'd be willing to share?
Oh, sure. It's just kind of little interesting scenarios I've seen. Is that the question?
That'd be great. Of course,
Yeah.
changing names to protect the innocent. But yeah.
Yeah, absolutely. Yeah, there's a couple. I mean, I've number one, just one should be really meticulous in any sort of self-help with an NDA. I've had occasion to, share, create or share a form NDA that was versatile, for a given company's needs, and to say, okay, just fill out these 3 things, and I've otherwise kept it, really, you don't have to fill out many parts of the agreement. It's otherwise going to stay pretty stationary, but fill out these few things, and here are some guidelines. And I will tell you, it can be amazing to see how convoluted, what seems like harder than just doing it the way I suggested. One might do it and then end up doing the very opposite, like basically like making the whole thing not confidential that they're sharing. So you got to be really careful and not try to get fancy. If you're you need to really make sure that when you read it, it really says what you think it's supposed to say. So I've seen that situation more than once, and I don't recommend any sort of hasty self-help if you're going to help yourself. Another thing is sometimes you'll see as companies are starting to grow, and they maybe are having corporate structures that are expanding, which is really great and exciting when companies find themselves in that situation. But sometimes they don't realize that when they take an employee or some other contractual relationship, and they really start running it out of another entity, like they have an affiliate, and they want that affiliate to now be the employer, and they do everything properly with payroll, et cetera, or the vendor, and they're paying them out of that other company, but they haven't actually signed an NDA, but they're with the other entity, and they're continuing to share more and more confidential information over time, just by nature of whatever that business relationship is. That can be a situation, and I've seen it. I've seen that situation where I've said, hey, all that information that you're sharing is not actually covered by this NDA, because that's with your affiliate over there. That's not with this entity. Now, sometimes NDAs will be written in a way, though in this case, the most recent time it happened, it was not the case. An NDA can be written to cover information about affiliates, but if it doesn't say that it covers information about affiliates, then it probably doesn't. So, that's another kind of mini war story that people should be cautious about. And then I think just that one, just to re-mention it, because I just don't think it's great language, and you do see it from time to time, this undertaking of having to really affirmatively make sure that every single thing you say or write specifically says it's confidential if you want it to be treated confidentially. I just don't think that that's the best language to include in an NDA, and I've seen that more times than I can count. And I've also said to the business people involved, like, do you really think you're going to do that? I mean, no offense, I would have a hard time doing it, but do you really think you're going to do that? And so I think those are kind of, NDAs aren't the juiciest. Well, they are, I guess, in today's news, like you were mentioning earlier, but in the day-to-day operation of businesses not doing anything salacious, just trying to get business done, do some, bring a cool new product to market, or providing services, or growing a business. I mean, usually, it's not the most exciting thing. It's actually pretty fundamental. But those are the types of areas that I see people get into trouble.
Well, Heather, I just want to say thank you so much for taking the time to share your insights with our audience.
My pleasure.
As always, it's a pleasure chatting with you. For more information, or to access all of our other podcasts, webinars, and other helpful information, please visit us at www.lawhelp.org/DC/CED. On Twitter, you can follow Heather at Batzel Law, BATZELLAW. You can follow me at Darryl J. Maxwell, DARRYLJ Maxwell, or you can follow the Pro Bono Center at DCBAR Pro Bono. Thank you so much for joining us. Hope to talk to you soon.
Great. Thanks.